Welcome back to the deep dive. Last time, we navigated cause and fact, which, asks the basic question. Did the defendant's negligence physically lead to the injury?
The but-for test.
Exactly. But that's just the starting line. Today, we're tackling the second great hurdle, the legal gatekeeper known as proximate cause.
Right.
This is where it gets complicated because it asks, even if the defendant was the but-for cause, should the law actually hold them responsible for this specific injury? It's where the system draws a line.
It's all about limiting liability, really. It's a question of legal policy and fairness, preventing this endless chain of responsibility from one single mistake.
So our mission today is to really get into the weeds, a rigorous element-by-element analysis of how courts do that.
That's right. And the primary tool for that is the foreseeability test. We're going to use a two-step framework. First, we need to understand the type of harm the test covers.
Okay.
And then second, we have to rigorously dissect the major exception to liability, the whole concept of superseding intervening forces.
Okay, let's unpack this immediately. Before we get into any exceptions, what is the black letter rule for establishing proximate cause through that main foreseeability test?
So the general rule is that proximate cause is established if the defendant should have reasonably foreseen the, let's call it the general consequences or type of harm that the plaintiff suffered as a risk of their conduct.
So it's a two-part inquiry.
It is. It has to be satisfied sequentially. First, you need a reasonably foreseeable result or type of harm.
And second?
And second, there can't be a superseding intervening force that breaks the causal chain.
Ah.
And here's the crucial nuance, the thing that trips up even experienced lawyers. While the type of harm has to be foreseeable, the law generally says the extent of the damage and the precise manner in which it all happens. Those do not need to be foreseeable.
That distinction, foreseeable type versus unforeseen manner, is so important. And there's no better case for this than the famous one, Petition of Kinsman Transit Co. Let's analyze it now. First, what are the legally dispositive facts?
Okay, so the case is this comedy of errors on the Buffalo River. The defendant's ship, the Kinsman, was improperly moored. It just breaks free.
Just breaks loose.
Floats downstream and crashes into a second ship that was properly moored. Now you have two ships drifting down together, and they smash into a city drawbridge.
And the bridge couldn't be raised?
Right. Due to some separate negligence, they couldn't get it up in time. So this pile of wreckage, plus all the river ice, creates a massive blockage. It effectively dams the river.
Wow.
And this causes substantial upstream flooding, damaging property for owners who were, miles away from the initial collision.
The physics here are just wild. It's like a disaster movie script. So is the legal sticking point the fact that the flood damage itself was just too remote, or was it that whole bizarre chain of events?
That's it, exactly. The core legal issue was whether the property damage from that upstream flooding, which resulted from that specific very complex chain of events, was a foreseeable type of harm from just, negligently mooring a boat.
Judge Friendly wrote the opinion here, and he made a ruling that really expanded the scope of liability. What was the exact rule of law he applied to draw the line and still hold them responsible?
So Judge Friendly ruled that proximate cause was satisfied when, and I'm quoting here, the damages resulted from the same physical forces whose existence required the exercise of greater care than was displayed and were of the same general sort that was expectable.
Okay.
And he stressed that the unforeseeability of the exact developments and the extent of the loss won't limit liability. So his rule has two testable elements.
What are they?
First, the damage has to result from the physical forces risked by the negligence. And second, the damage has to be of the same general type that was expectable.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, that the damage results from the physical forces risked?
Well, the sub-issue there was whether the force of the river water and the structural failure of the ships and bridge actually counted as the forces risked by bad mooring. And the court found, yes. The risk created by negligent mooring involves ships colliding, running amok, creating blockages, affecting the river. The flood damage was directly caused by that blockage. So since ships and water were the forces involved, this element was met.
Right. But here's the tough part. Property damage miles upstream seems so far removed from a ship collision. How did the court justify the second element, that the general type of harm was still expectable?
That was the real fight. The sub-issue was, is flooding upstream property just too remote? But the court held that property damage and collision damage in a busy waterway system like the Buffalo River is exactly the general sort of consequence that makes mooring negligence so dangerous.
So the mechanism was weird, but the result wasn't.
Exactly. The exact mechanism, the bridge failing, the ice damming things up, that was unforeseen. But the type of harm, which was large-scale water-related property damage from a blocked channel, that was expectable. So this element was also met.
And after analyzing all the elements, what was the court's final conclusion?
The court held the defendants liable for all that upstream flooding. The conclusion really affirmed that the foreseeability test focuses on the risk created by the initial negligence, the danger of a loose ship, not on a highly specific, bizarre chain of events that leads to the injury.
Okay, here's where it gets, I think, really interesting, because now we get to the escape hatch. Even if the type of harm is foreseeable, a defendant can be relieved of liability if there is a superseding intervening force. So what is an intervening force and what makes it superseding?
An intervening force is just a new force. It could be a person's action, mechanical failure, a natural event, anything that occurs sequentially in time after the defendant's negligence and joins with it to cause the harm. It's just a new factor on the timeline.
Okay, just a new event, but what's the test to make it superseding?
Right, that's the critical question. An intervening force is generally seen as superseding only when its occurrence seems extraordinary under the circumstances. Some courts describe it as an occurrence so highly improbable and extraordinary as to bear no reasonable connection to the harm threatened.
So it has to be a real freak occurrence.
Yes, the policy is that a defendant should foresee normal human mistakes and normal natural risks, but not truly bizarre out-of-the-blue events.
Let's test that highly improbable rule against an act of nature with Johnson v. Cosmos Portland Cement Co. First, what are the legally dispositive facts?
In this case, the defendant had negligently let highly flammable gas collect inside a barge that was moored on a river. The injury happened when lightning struck the gas-filled barge and caused a massive, fatal explosion.
So the key legal question boiled down to, is an act of nature, like a lightning strike, automatically a superseding intervening force that breaks the chain? What was the core legal issue?
The issue was precisely that. Did the lightning striking the negligently gassed-up barge constitute a superseding intervening force, and therefore relieve the defendant who created that explosive environment of liability?
What rule of law did the court apply here for an act of nature? What's the standard for when a natural event becomes superseding?
The rule is that the operation of natural forces doesn't count as an intervening agency unless it's of such exceptional violence, so extraordinary, that human prudence would not have foreseen or provided against them.
Thank you. Now for the court's elemental analysis. How did the court specifically analyze that lightning strike against the standard of exceptional violence?
The court did a kind of mini-analysis on lightning itself. It concluded that lightning was, at least at the time and place here involved, no extraordinary manifestation of natural force.
So lightning isn't extraordinary enough?
Not in this context. Although the lightning was the immediate trigger, the general risk of fire or explosion was already made huge by the defendant's negligence. The risk of lightning was just seen as a reasonably possible contingency, just like a spark from a machine or a dropped cigarette.
And what was the court's final conclusion?
The court upheld liability. It basically said that because the type of harm and explosion was exactly the risk created by the gas, the specific means of ignition, the lightning, didn't have to be foreseeable to maintain liability.
So what does this all mean for human actions? Let's say I carelessly spill a bunch of gasoline at a service station. Fire is a foreseeable risk. If you then carelessly drop a lit match nearby, your action is an intervening force. Is your negligence superseding?
No, absolutely not in that context. Negligently dropping a match near spilled gasoline is not extraordinary or highly improbable. It's, part of the general risk of having flammable stuff around people.
But what if I intentionally drop the match? Arson.
Ah, now that's different. A criminal act like arson is more likely to be seen as superseding. Courts look at criminal intent differently.
So it's always superseding.
Not always. For instance, if the original negligence created the risk of a crime like, say, negligently leaving a bank vault door wide open overnight, the subsequent intentional theft might be considered foreseeable and therefore not superseding.
Let's discuss complicated but very common subsequent harms. What about aggravated harm from medical errors or accidents? For example, a victim is injured by a defendant and then dies when their ambulance driver has a heart attack and crashes.
Right. The key policy distinction there is that those kinds of subsequent harms are generally not superseding.
Really? Even a heart attack?
Yes. The law holds that routine medical malpractice, or even accidents during a rescue or transport, are risks the original tortfeasor exposed the victim to by injuring them in the first place. The need for an ambulance and medical care is a direct foreseeable result of the initial injury.
So what would it take for medical malpractice to be superseding? Where is the line that actually breaks that chain?
It would have to be truly extreme, something that fits that highly improbable and extraordinary test I talked about. Think of a surgeon amputating the wrong leg or knowingly giving a patient a drug they're violently allergic to.
Eh.
Acts so far outside the bounds of ordinary negligence that a court might say, okay, that breaks the chain. And one final point courts weigh heavily is the lapse of time. Proximate cause is very fact-specific. If there's a huge lapse of time, say 17 months, like in one case, a court might decide that the later failure by someone else to inspect or maintain something had become the truly superseding cause, relieving the first person of responsibility.
This has been a fascinating deep dive into the legal limits of responsibility. We covered foreseeable harm with kinsmen and the extraordinary exception with cosmos and human actions. Now, for you, the listener, let's synthesize all this into an actionable diagnostic checklist.
Absolutely. When you're analyzing proximate cause, use this step-by-step checklist to structure your thinking. First step.
Go ahead.
1. Foreseeability check. Was the type of harm reasonably foreseeable as a risk of the defendant's conduct? If no, you stop. Liability is cut off. If yes, you proceed, and remember the exact manner doesn't matter.
Okay, step 2.
2. Identify intervention. Look for any new force-human mechanical natural exam that happened after the defendant's negligence. 3. Superseding analysis. This is the core. Apply that highly improbable and extraordinary test. Was this intervening force totally outside the normal course of events threatened by the original negligence?
And 4.
Or, factor check. Evaluate the force's nature. Is it an act of nature? An intentional crime? Routine medical negligence? And remember, standard medical risks and transport accidents are almost never superseding.
And finally,
5. Conclusion. Only if that intervening force is found to be truly extraordinary, highly improbable, and remote is the original defendant relieved of responsibility.
a final provocative thought for you to mull over on your own. We've established that proximate cause is ordinarily a question of fact for the jury. Given the incredible complexities of modern systems, from healthcare chains to global shipping, what stands out to you as the biggest policy justification, beyond just simple fairness, for allowing one negligent party to get off the hook because of a subsequent extraordinary act?